Case 1, Kristie Haas. June 1st, 2019 through September 13th, 2019. Kent County Superior Court, Delaware. There are moments in a criminal investigation when seasoned law enforcement officers, people who have spent entire careers walking through the aftermath of the worst that humanity has to offer, find themselves standing in a field, staring at evidence before them, and struggling to process what they are seeing. Not because they lack experience, not because they are unprepared, but because what is in front of them defies every expectation they carry into the job about what one human being is capable of doing to another, especially when that other human being is a child, especially when that child was 3 years old, and especially when the person responsible was the one person on this earth who was supposed to love her more than anyone else. That is where this story begins. Not in a courtroom, not in a police precinct, but in a field in Smyrna, Delaware, on a September afternoon in 2019, when what investigators found in those softball fields behind a community park would set in motion one of the most devastating child welfare cases the state of Delaware had seen in years. Her name was Emma Grace Cole. She was 3 years old, and she deserved so much better than the world gave her. Smyrna, Delaware is the kind of small town that carries its identity quietly. Sitting in Kent County, roughly halfway between Wilmington in the north and Dover in the south, Smyrna is a community of approximately 12,000 residents. It has tree-lined streets, youth sports leagues, churches on corners, and the kind of neighborly familiarity that makes residents feel they know one another well. It is the kind of place where children are supposed to be safe, where a little girl like Emma Grace Cole should have been learning her letters, testing the limits of a backyard, laughing at cartoons, and being tucked in at night by someone who loved her deeply. But Emma Grace Cole had not been seen for months before September 2019, and the people who should have been looking for her had said nothing to anyone. The circumstances that brought Emma into the world were complicated from the start. She was born to a young mother in Delaware, and from her earliest days, Emma's life was shaped by instability in ways that a 3-year-old child could never understand and certainly never deserved. The adults responsible for her care cycled in and out of situations that were not safe, not stable, and not anchored in the kind of consistent, attentive parenting that small children require simply to survive. Kristie Haas entered the picture as a caregiver figure in Emma's life. While the precise legal and familial designation varied throughout the case, the courts ultimately treated Haas as the person in a position of primary custodial responsibility for Emma during the period in which Emma lost her life. That responsibility, that duty of care, is what sat at the center of every charge the Delaware Department of Justice eventually brought against her. What investigators established through the course of their inquiry was a picture of neglect and abuse so severe, so prolonged, and so deliberately concealed that it shocked even the most experienced members of the Delaware law enforcement community. Emma Grace Cole did not simply fall ill. She did not simply experience an accident. She was subjected to conditions of profound neglect and harm over a sustained period, conditions that ultimately proved fatal to a child who had no ability to seek help, no voice loud enough to be heard beyond the walls of whatever space she occupied, and no protector willing to intervene. The investigation into Emma's fate began in September 2019. Delaware State Police, along with investigators from the Division of Family Services, began piecing together a timeline of Emma's whereabouts going back to the early summer months of 2019. What they found, or more precisely, what they found they could not find, was deeply troubling. Emma Grace Cole had effectively vanished from any documented record of activity. No school enrollment, no medical appointments, no welfare checks, no sightings by neighbors or community members who might have previously seen her. It was as though she had simply ceased to exist. And then, in September 2019, the discovery at the Smyrna softball fields changed the nature of the investigation entirely. The remains of a small child were found at the recreational fields in the Smyrna area. The state medical examiner was called to the scene. Forensic analysis began, and in the days that followed, investigators confirmed what the evidence had been pointing toward. The remains were those of Emma Grace Cole. She had been there, in that field, for some time before anyone found her. The question was no longer where Emma was. The question became what had happened to her, and who was responsible. Kristie Haas came to the attention of investigators quickly. The timeline, the circumstances, and the custodial history all pointed in her direction. As the investigation deepened, what authorities uncovered was a pattern of conduct so far removed from even the most minimal standard of parental responsibility that prosecutors ultimately pursued the most serious charges available under Delaware law for cases involving harm to a child under one's care. The charges brought against Kristie Haas were as follows: 1 count of murder by abuse or neglect in the first degree, 1 count of abuse of a corpse, and 3 counts of endangering the welfare of a child. The murder by abuse or neglect charge, one of the most serious charges in Delaware's criminal code as it pertains to child victims, reflected the prosecution's position that Emma's passing was not an accident, not an isolated incident, but the foreseeable and preventable outcome of sustained, deliberate harm and criminal negligence inflicted upon a child who had no ability to protect herself. The abuse of a corpse charge added a layer of accountability that spoke to what happened after Emma lost her life, the manner in which her remains were handled, concealed, and ultimately left in a public recreational space, as though the evidence of a crime could simply be discarded. The 3 counts of endangering the welfare of a child indicated clearly that Emma was not the only child whose safety had been compromised in this household. There were other children present whose welfare, the state determined, had been placed at serious risk by the environment maintained by Kristie Haas. 3 children, 3 separate counts, 3 more lives touched by the consequences of this case. As the legal process moved through Kent County Superior Court, it became clear that the evidence assembled by investigators and prosecutors was substantial. The case was not built on circumstantial whispers. It was built on forensic findings, witness accounts, timeline analysis, and the weight of documented fact. Faced with that evidence, Kristie Haas entered a guilty plea to the charges against her. She stood before a judge in Kent County Superior Court and admitted her role in what happened to Emma Grace Cole. The sentencing hearing that followed was, by all accounts, a solemn and emotionally heavy proceeding. The court heard from those impacted by Emma's passing. The judge reviewed the facts of the case, the nature of the charges, and the circumstances of the offense. And then the court rendered its judgment. Kristie Haas was sentenced to 30 years in Delaware State Prison. 30 years for what was taken from Emma Grace Cole. 30 years as the court's declaration that a 3-year-old child's life carried weight, carried value, and carried the full protection of the law, even when every adult around her had failed to protect her while she was still alive. The case reverberated through Delaware's child welfare community in significant ways. In the aftermath of Emma's case, questions arose about the systems and structures that existed or failed to exist to identify children in situations of serious risk before those situations became tragedies. Emma Grace Cole had been invisible to institutions that should have had their eyes on her. The challenge of reaching children who have been deliberately isolated from community systems, no school, no medical care, no regular public presence, is one that child welfare advocates across the country continue to grapple with today. Emma's case became a reference point in those conversations. A name attached to a policy gap. A 3-year-old face attached to an argument for stronger, more proactive systems of child protection. In Delaware, the tragedy of Emma Grace Cole contributed to broader discussions within the Division of Family Services and related government agencies about how to better identify and respond to situations where children are being kept away from the institutions and systems that would otherwise provide natural oversight of their welfare. These are not easy conversations. They require resources, coordination, political will, and a cultural commitment to treating child protection as a genuine public priority rather than a bureaucratic checkbox. What is certain is this: Emma Grace Cole was a child who deserved to be seen. She deserved to be protected. She deserved the full weight of every system and every adult in her orbit to stand between her and the harm that eventually reached her. She did not receive that protection, and the state of Delaware, through its courts, its investigators, and its prosecutors, made certain that the person responsible for that failure was held accountable in the fullest manner the law allowed. Kristie Haas will spend 30 years in Delaware State Prison. Emma Grace Cole would have been approximately 9 years old at the time of Haas's sentencing. She would have been learning to read chapter books, riding a bike, asking endless questions about the world around her, and discovering exactly who she was going to become. Instead, she is remembered. And her name, Emma Grace Cole, deserves to be spoken clearly, carefully, and with the full gravity of what her short life represents. Not a statistic, not a footnote, but a child. A real child, whose life mattered completely. If you or someone you know has concerns about the safety or welfare of a child, please contact the Child Help National Child Abuse Hotline at 1-800-422-4453. Trained counselors are available 24 hours a day, 7 days a week. If this case moved you, if Emma's story made you feel the urgency of why conversations like this one matter, please take a moment right now to like this video, leave a comment below, and subscribe to Cold Case Hour so you never miss a story. Your support helps this channel continue bringing important cases into the light. Every like, every comment, every subscription is a way of saying that these stories matter, that these lives matter. Hit that subscribe button, and let's continue. Case 2, Darrian Randle. June 9, 2025. Cecil County Circuit Court, Maryland/New Castle County Court of Common Pleas, Delaware. There are criminal cases that unfold quietly, discovered gradually, pieced together over weeks or months by investigators working methodically through evidence. And then there are cases that erupt into public view instantly. Cases that begin with a frantic emergency call, expand into a multi-state search operation, trigger Amber Alerts, and capture the attention of entire communities before the truth behind them has fully surfaced. The case of Darrian Randle belongs firmly in the second category. On the morning of June 10, 2025, a woman named Darrian Randle walked into a police station in Newark, Delaware, and reported something that every parent, every community member, and every law enforcement officer dreads hearing. She told authorities that her 3-year-old daughter, Nola Dinkins, had been kidnapped. She provided a description. She gave details. She presented herself as a mother in crisis, desperate for help, reaching out to the only people who could bring her child home. Within hours, an Amber Alert had been issued across Delaware and into neighboring states. Law enforcement agencies mobilized. The public was alerted. People across the region began watching, waiting, and hoping for a safe outcome for a 3-year-old girl who, according to her mother's account, had been snatched away by unknown individuals. But Nola Dinkins had not been kidnapped by strangers. And Darrian Randle was not the terrified mother she appeared to be. What followed over the next several weeks was one of the most disturbing revelations in recent Delaware and Maryland criminal history. A case that exposed not just the details of one family's private tragedy, but raised urgent, painful questions about what happens to children when no one outside their home is watching closely enough. Darrian Randle was 31 years old at the time of the events of June 2025. She lived with her daughter Nola in the Newark, Delaware area, a college community in New Castle County, home to the University of Delaware, a place with a bustling downtown, a transient population of students and young families, and a community infrastructure that, in theory, should have had multiple touchpoints with a young child like Nola Dinkins. What investigators eventually established, through evidence gathered across state lines, through forensic analysis, through witness accounts, and ultimately through Randle's own admissions, was a timeline that began not on June 10th when the false kidnapping report was filed, but on June 9th, the day before. According to investigators and court documents, Darrian Randle administered harm to her daughter Nola on the morning of June 9th, 2025, in a manner that caused Nola's passing. The precise circumstances, what led to that moment, what occurred in that space, are part of the ongoing legal proceedings. What is documented is that Nola Dinkins lost her life in her mother's care on that morning. Rather than reporting what had happened, rather than calling for help, rather than doing any of the things that every moral and legal obligation demanded of her in that moment, Darrian Randle made a different choice. She chose concealment. She chose deception. And she chose to construct an elaborate fabrication designed to redirect attention away from herself and toward an imaginary perpetrator. Randle wrapped Nola's remains and placed them inside a suitcase. She then transported that suitcase across state lines from Delaware into Maryland, where she left it in the northeast Maryland area, a small community in Cecil County, roughly 30 miles from Newark. She then returned to Delaware, went to the Newark Police Department, and filed her false kidnapping report. The Amber Alert that followed was, in the starkest possible terms, a search for a child who was already gone. Law enforcement agencies, Community volunteers and members of the public who responded to that alert were unknowingly participating in a search that Darrian Randle knew could never succeed. The investigation moved quickly once law enforcement began examining the inconsistencies in Randle's account. When the details of a reported kidnapping do not align, when timelines shift, when descriptions change, when the emotional responses of a reporting parent do not track with what investigators expect to see, experienced detectives know to look more carefully at the person sitting across from them. Maryland State Police became involved as evidence pointed toward Cecil County. On July 11, 2025, investigators located a suitcase in the Northeast Maryland area. Inside the suitcase, consistent with what forensic analysis would later confirm, were the remains of a small child. The remains were subsequently identified through forensic examination as those of Nola Dinkins. According to Maryland State Police, the forensic findings indicated that Nola had experienced profound neglect and harm prior to her passing. The condition of her remains spoke to circumstances that extended well beyond a single incident, circumstances that pointed to a pattern of treatment that had gone unobserved, unreported, and unaddressed during Nola's short life. Darrian Randle was taken into custody. She was charged in Maryland with first-degree murder and child abuse resulting in the passing of a minor. She was additionally charged in Delaware with filing a false police report in connection with the fabricated kidnapping claim. The two jurisdictions, Maryland and Delaware, coordinated on the multi-state case, with primary criminal charges centered in Cecil County, Maryland, where the remains were found and where Maryland prosecutors have jurisdiction over the most serious charges. As of the time of this documentary, the legal proceedings against Darrian Randle are active and ongoing. She has been charged, but, as the case moves through the Maryland court system, a trial date and final adjudication remain ahead. The presumption of innocence applies to all accused persons until a court renders a verdict. What is established in the public record are the charges, the forensic findings, and the circumstances of the investigation as documented by law enforcement officials across two states. What is not in dispute, and what sits at the undeniable center of this story, is Nola Dinkins herself. Nola was 3 years old. She had a name that carried love in it. She was a child who, by every measure of what childhood should be, deserved protection, warmth, nourishment, safety, and the unconditional presence of a parent who chose her every single day. The Amber Alert that went out in her name, the one that prompted communities across Delaware and Maryland to look for her, to check their neighborhoods, to share information on social media, to genuinely hope for a safe outcome, was a testament to the instinct of communities to protect their children. The tragedy is that the person who should have protected Nola most was the one who had already made that search impossible. Cases like Nola's raise uncomfortable and essential questions about early intervention, about the systems of oversight and support that can, when functioning properly, identify families in crisis before a crisis becomes irreversible. Home visiting programs, early childhood education enrollment, pediatric health check-ins, child welfare agency contacts. These are the institutional touchpoints that can make the difference between a family receiving needed support and a child disappearing from view entirely. Nola Dinkins was 3 years old, the same age as Emma Grace Cole, whose story opened this documentary. That is not a coincidence the court system tracks. It is simply the heartbreaking reality that very young children, preschool age, pre-institutional, are among the most vulnerable to harms that occur in private spaces with no external witnesses. Delaware and Maryland child welfare advocates have pointed to cases like Nola's as evidence of the urgent need for stronger, more proactive systems of early childhood engagement. Systems that reach families before tragedy occurs. Systems that treat child welfare not as a reactive emergency response, but as a continuous, community-wide commitment. Darrian Randle faces the full weight of the judicial systems of both Maryland and Delaware. The case continues to move through the courts. Justice for Nola Dinkins remains an active and ongoing pursuit. And Nola Dinkins, 3 years old, with a name and a face and a life that was just beginning, deserves to be remembered not as a case file, but as a child. A child who was loved by a community that searched for her. A child whose story, as painful as it is to tell, must be told, because silence is what allowed her situation to reach its tragic conclusion, and awareness is the first step toward ensuring it does not happen again. If you have concerns about the safety of a child in your community, please do not hesitate to contact local authorities or the Child Help National Child Abuse Hotline at 1-800-422-4453. If this story has moved you, please take a moment to like this video and subscribe to Cold Case Hour. Leave a comment below. Your thoughts and your engagement help this channel continue bringing these stories to the people who need to hear them. Every case on this channel is told in honor of the people at the center of it. Subscribe now, and let's continue. Case 3, Tasha Purnell. August 1st, 2010 through July 31st, 2014. Newcastle County Superior Court, Delaware. There is a particular category of betrayal that sits apart from all others in the landscape of criminal conduct. It is the betrayal that occurs not between strangers, not between adversaries, but between a person in a position of authority, trust, and care, and the young person who has been placed in their charge. It is a betrayal that does not announce itself. It does not arrive with warning signs visible to the untrained eye. It hides behind professional credentials, community respect, and institutional trust. And when it is finally uncovered, it leaves a damage that is measured not in visible injuries, but in the long, difficult journey of recovery that follows. The case of Tasha Purnell is exactly that kind of case. Tasha Purnell, also known professionally as Tasha Oliver, was, by every external measure, a success story. She was an educator in Delaware's public school system, a professional who had worked her way through the academic ranks to positions of genuine institutional authority. She was known to colleagues, administrators, and parents as a dedicated education professional. She occupied spaces of influence and responsibility that placed young people directly in her orbit, under her supervision, and subject to her authority. Between August of 2010 and July of 2014, a period of nearly 4 full years, Tasha Purnell used that position to commit a series of crimes against a child that would ultimately result in one of the most significant educator misconduct prosecutions in Delaware's recent history. The victim was a young female student. She was under the age of 16. She was, in every meaningful sense, under the institutional care and authority of her school system and the professionals employed within it. Her name has been protected throughout the legal proceedings, as a standard practice in cases involving juvenile victims of this nature, and this documentary will honor that protection fully and completely. What investigators and prosecutors established through the course of the inquiry was that Purnell engaged in a sustained pattern of criminal sexual conduct toward this student over the course of nearly 4 years. The offenses occurred during the period when Purnell was employed at Stanton Middle School in Newcastle County, Delaware. The school sits within the Kristina School District, one of Delaware's larger public education systems, serving thousands of students across multiple communities in Newcastle County. For years, the conduct continued without detection. The victim was a child navigating a situation that children are fundamentally not equipped to navigate, a situation involving an adult in authority, a power imbalance that is by its nature overwhelming, and the complex psychological dynamics that accompany any relationship between a young person and a trusted adult who is causing them harm. Research into these kinds of cases consistently shows that young victims often do not disclose what is happening to them, sometimes for years, because they do not fully understand what is occurring, because they fear they will not be believed, because they have been conditioned by the relationship itself to remain silent, or because the social and institutional power of the adult perpetrator makes disclosure feel impossible. The victim in this case eventually came forward. That act of courage, the decision to speak, to report, to place trust in the systems that had in some ways failed to protect her, set in motion the investigation that ultimately brought Tasha Purnell before the courts. The Delaware Department of Justice built a case that addressed the full scope of the conduct. The charges that prosecutors brought against Purnell were precise and serious. 2 counts of rape in the 3rd degree, 1 count of continuous sexual abuse of a child, and the underlying aggravating factor that Purnell had committed these offenses while in a position of trust and authority over her victim. In Delaware, as in many states, the abuse of a position of authority in the commission of offenses against a minor is treated as a significant aggravating circumstance, one that speaks to the deliberate exploitation of an institutionally sanctioned relationship for criminal purposes. Tasha Purnell did not go to trial. On May 12, 2025, She appeared before the New Castle County Superior Court and entered a guilty plea to the charges against her. She acknowledged her conduct. She stood in a courtroom and admitted, through the formal legal mechanism of a guilty plea, that what she had done to that child over 4 years was wrong, was criminal, and warranted the court's judgment. The guilty plea, while representing a significant step in the legal process, was by no means the end of the case's impact. Sentencing proceedings followed, during which the court heard the full weight of what the victim and her family had endured, not just during the 4-year period of the offenses, but in the years that followed, as the victim worked through the long process of recovery, understanding, and reclamation of her own story. The case also raised significant questions within the Delaware public education community. Tasha Purnell had not remained a classroom teacher throughout the post-offense period. She had, in fact, continued to advance within the educational system. She subsequently served in an administrative capacity at AI DuPont Middle School in Wilmington, Delaware, another New Castle County institution serving a student population. That trajectory, from Stanton Middle School to an administrative role at another school, prompted serious examination of the background check systems, reporting mechanisms, and institutional oversight protocols that govern employment decisions in Delaware's public schools. How does a person who is committing offenses against a student in one school continue to advance within the same educational system? What institutional processes should have identified the risk before it could extend further? These are questions that the Delaware Department of Education, school administrators, and child safety advocates took seriously in the wake of this case. The answers are not simple. They require systemic commitment to the primacy of student safety over institutional inertia, bureaucratic convenience, or the professional reputations of individual employees. The victim's courage in coming forward was ultimately the mechanism that brought accountability where accountability was due. But the broader lesson of this case is that systems need to be structured so that the burden of accountability does not rest entirely on the shoulders of the young person who was harmed. Children should not be the last line of defense against the very adults who are supposed to protect them. Tasha Purnell's guilty plea represented a formal acknowledgement by the court and by Purnell herself that a serious wrong had been committed. The sentencing outcome, formally entered in New Castle County Superior Court, reflected the gravity of 4 years of sustained criminal conduct against a child who trusted the system that placed her in Purnell's proximity. The victim in this case, whose identity remains protected and whose privacy this documentary fully respects, went on to do what many survivors of similar situations do. She built her life. She found her voice. And through the legal process that her disclosure initiated, she became the reason that the institution of education in Delaware had to examine itself and ask harder questions about how it protects the young people in its care. That is a legacy, an unwanted one, born from pain and violation, but a legacy nonetheless. And it matters. For anyone who has experienced harm at the hands of a trusted adult in an institutional setting, support is available. RAIN, the Rape, Abuse, and Incest National Network, operates a confidential hotline at 1-800-656-HOPE. Trained staff are available to provide guidance, support, and resources 24 hours a day. If this case resonated with you, if it made you think about the systems we build to protect young people and how we hold those systems accountable, please take a moment to like this video and subscribe to Cold Case Hour. Leave a comment below with your thoughts. Your engagement keeps this channel going, and every story told here is told because it matters. Subscribe now, and let's continue. Case 4, Mercedes Ferguson. August 18, 2023. New Castle County Superior Court, Delaware. There are certain cases in the criminal justice system that prosecutors, investigators, and court officers carry with them long after the legal proceedings have concluded. Cases that resist being filed away and forgotten. Cases where the victim's identity, their specific, individual humanity, refuses to be reduced to case numbers and evidentiary exhibits. Cases where the weight of what happened sits with everyone who touched the file, because the facts are simply too stark, too close, and too avoidable to accept with professional distance. The case of Mercedes Ferguson is one of those cases. In the early hours of August 18, 2023, emergency services received a call from a residence on Court Drive in Wilmington, Delaware, specifically in the New Castle County area of the city. The caller reported a child in medical distress. First responders arrived at the address and found a 4-year-old boy in a condition that immediately triggered alarm. He was transported to a medical facility. Evaluating physicians documented what they found with clinical precision. What their documentation revealed was not the result of an acute illness or sudden medical event. What it revealed was the result of sustained, severe deprivation over an extended period. The child, a 4-year-old boy in the care of his mother, Mercedes Ferguson, weighed 23 pounds at the time he was found. 23 pounds. For context, the medically expected weight of an average 4-year-old child in good health is approximately 35 to 40 pounds. The gap between those numbers is not a minor variation. It is not a reflection of a small frame or a naturally slender build. It is a gap that the state medical examiner, the attending physicians, and ultimately the courts characterized as the direct consequence of chronic, severe starvation. This child had not been fed, not adequately, not consistently, and not for a long time. He did not survive. The official cause of his passing, as determined by the Delaware Division of Forensic Science, was homicidal starvation, a finding that carried profound legal and moral implications. Homicidal starvation is not an accident. It is not an oversight. It is not the result of poverty alone or a single moment of neglect. It is a condition that develops over weeks and months, visible to anyone with access to the child, requiring a sustained and deliberate failure of every parental obligation. Feeding, caring, attending to the most fundamental physical needs of a human life. Mercedes Ferguson was the child's mother. She was present in the home. She was the adult responsible for ensuring that her son received nourishment, medical attention, and the basic physical care that a 4-year-old child is entirely dependent on an adult to provide. New Castle County Police initiated their investigation immediately upon the child's arrival at the medical facility. The investigation moved through the standard forensic and testimonial channels with the kind of institutional urgency that cases involving a child's passing always generate. What investigators documented painted a picture of a living environment that had been, for an extended period, one of acute deprivation for the child within it. Mercedes Ferguson was taken into custody and charged with murder by abuse or neglect in the first degree, child neglect resulting in passing, and endangering the welfare of a child. The murder by abuse or neglect charge, the most serious charge available under Delaware law in this category of case, reflected the prosecution's determination that the child's passing was the direct, foreseeable, and legally attributable result of Ferguson's conduct. The legal proceedings that followed moved through New Castle County Superior Court. As the case developed, the prosecution and defense engaged in the kind of careful legal negotiation that is common in serious cases of this nature, a process aimed at reaching a resolution that reflects the facts, the law, and the interests of justice without the additional trauma of a full trial. On January 23rd of the year following the offense, Mercedes Ferguson appeared before the court and entered a guilty plea to a reduced charge of manslaughter. The reduction from murder by abuse or neglect to manslaughter reflected a negotiated legal resolution, one that still carried the full weight of criminal accountability, still placed Ferguson's conduct before the court as a serious criminal act, and still resulted in a significant sentence. The sentencing range for manslaughter in Delaware is 2 to 25 years in state prison. The court, having reviewed the facts of the case, the forensic findings, the nature of the harm, and the circumstances of the offense, imposed a sentence within that range. It is worth pausing for a moment here, not to enumerate the legal technicalities of plea negotiations or sentencing guidelines, but to return to the human being at the center of this case. A 4-year-old boy, a child in the phase of early childhood development where the world is supposed to be full of discovery, language, play, imagination, and the foundational security of a parent's reliable presence. A phase where children begin to understand the concept of family, where they form their earliest attachments, where they take their first steps into understanding who they are and what the world holds for them. This child's world held starvation. His world held a home where the most basic obligation of parenthood, feeding a child, went unfulfilled to a degree that the medical examiner classified as homicidal. 23 pounds. That number does not belong in the medical chart of a 4-year-old boy. It belongs in a courtroom record as evidence of a failure so complete that the law treats it as a criminal act. And the courts of Delaware treated it that way. The case resonated deeply within Delaware's child welfare advocacy community. Organizations focused on early childhood nutrition, food security, and child welfare services referenced this case as a stark illustration of what can happen when a child is isolated from the community systems, schools, medical offices, social service agencies that serve as natural monitors of child welfare. A 4-year-old child who is not enrolled in preschool, who does not attend regular pediatric appointments, who does not have regular contact with community institutions, is a child whose condition may go entirely unseen by everyone outside the immediate household. The Supplemental Nutrition Assistance Program, the Women, Infants, and Children Nutrition Program, early childhood home visiting programs, and community health worker initiatives are among the resources that exist precisely to maintain contact with families of young children and to identify situations where additional support is needed. Their effectiveness depends, in part, on families being connected to them, and on the systems around those programs having the mechanisms to identify and reach families who have fallen through the gaps. Cases like this one are reminders that child welfare is not solely the responsibility of the families within which children live. It is a community responsibility, an institutional responsibility, and a governmental responsibility to ensure that no child is invisible to the systems designed to support them. Mercedes Ferguson entered a guilty plea, was sentenced, and is serving that sentence. The outcome reflects the accountability demanded by the law and the facts of the case. The child, her son, 4 years old, 23 pounds, deserved every protection, every resource, and every form of care that a community and a family could provide. He deserved to grow up. He is remembered. If you or someone you know is struggling to provide adequate nutrition or basic care for a child, resources are available. The Delaware 211 helpline connects families with food assistance, housing support, and child welfare resources. Dial 211 from any phone in Delaware to reach a trained resource specialist. If this story stayed with you, if this child's story reminded you of why these conversations matter, please take a moment to like this video, share it with someone who should hear it, and subscribe to Cold Case Hour. Leave a comment below. Your voice matters here, and every subscriber helps this channel continue telling the stories that deserve to be told. Hit that subscribe button right now, and let's keep going. Case 5, Krista Rule. June 25, 2023. Kent County Superior Court, Delaware. The cases that appear in criminal court records do not always fit the familiar narrative frameworks that people bring to true crime content. They are not always stories of strangers, of random violence, of predatory behavior directed at the vulnerable by the unknown. Sometimes they are stories of families, of relationships that had a history, a complexity, and a dynamic that the public can never fully know, where violence erupted in a domestic space and left a loss that no legal outcome can fully repair. The case of Krista Rule is one of those cases. On June 25, 2023, Delaware State Police responded to a call from a residential address on Case Ridge Road, in the Wolf Creek area of Dover, Kent County, Delaware. What troopers found when they arrived was a scene that triggered an immediate homicide investigation. 72-year-old Denise would have been found unresponsive inside her bedroom. She had sustained injuries consistent with a stabbing. Emergency medical personnel confirmed what the physical evidence made clear: Denise would have lost her life. The Delaware State Police Homicide Unit assumed control of the investigation. What followed was a meticulous, methodical process of evidence collection, witness interviews, timeline reconstruction, and forensic analysis. The kind of investigative work that homicide units conduct precisely because the circumstances of a person's passing demand a thorough and definitive accounting. The investigation identified a suspect. That suspect was Krista Rule, 46 years old, a resident of Wilmington, Delaware, and the daughter of Denise Wood. This case involves an element that sets it apart from others in this documentary. Krista Rule is not a mother who caused harm to a child in her care. She is a daughter accused of causing the passing of her mother. But she is included here because her case sits at the intersection of domestic violence, family crisis, and the criminal justice system's response to violence within the home, and because understanding the full scope of what courts in Delaware grapple with requires examining violence across all of its domestic contexts. The investigation into Denise Wood's passing proceeded carefully and deliberately. The Delaware State Police Homicide Unit is among the state's most experienced investigative bodies, and cases involving domestic homicide, where the suspect is a family member, require particular care precisely because of the complexity of the relationships involved, the physical evidence that exists within a shared or familiar space, and the investigative challenges of establishing both the facts and the context of what occurred. For a period following the June 2023 incident, the case remained under active investigation without a public arrest. This is not unusual in complex domestic homicide cases. Investigators frequently take time to ensure that the evidentiary record is complete before proceeding to charges, particularly in cases where the prosecution anticipates a vigorous legal defense. It was not until January of 2026, approximately 2.5 years after Denise Wood's passing, that Delaware State Police announced the arrest of Krista Rule. She was charged with murder in the first degree in possession of a deadly weapon during the commission of a felony. These are among the most serious charges in Delaware's criminal code, charges that, upon conviction, carry mandatory minimum sentences of significant length. The arrest warrant and associated court filings were processed through Kent County Superior Court, reflecting the Dover, Delaware location of the offense. As of the time of this documentary's production, Krista Rule has been charged and the case is proceeding through the pre-trial phase of Kent County Superior Court proceedings. A trial date has not yet been publicly announced, and the full adjudication of the case remains ahead. It is important to state clearly, as this documentary does with every case involving pending proceedings, that Krista Rule is presumed innocent unless and until a court of law renders a verdict of guilt. The charges against her are serious and documented. The investigation that led to those charges was extensive and conducted by experienced law enforcement professionals. But the legal process has not yet reached its conclusion, and that process exists precisely to ensure that every accused person receives a fair and thorough examination of the evidence before any final judgment is rendered. What is not in dispute is the loss of Denise Wood, 72 years old, a mother, a woman whose home on Case Ridge Road in Dover, Delaware, became a crime scene on a summer evening in 2023. A woman whose passing triggered a multi-year investigation, an eventual arrest, and criminal proceedings that are now working their way through the courts of Kent County. Domestic violence, the term that encompasses harm occurring within family and intimate partner relationships, is a category of criminality that exists across every demographic, every geography, every economic and social circumstance. It does not announce itself. It is rarely visible to outsiders until a moment of crisis reveals what has been occurring behind closed doors. And when it results in the loss of life, it leaves behind a particular kind of grief, the grief of families shattered from within, the grief of loss that comes not from a stranger's intrusion, but from within the fabric of the family itself. Delaware has invested significantly in domestic violence prevention and response infrastructure. The Division of Family Services, the Delaware Coalition Against Domestic Violence, and law enforcement agencies across the state work in coordination to respond to incidents of domestic violence and to provide support to those affected by it. The Delaware Domestic Violence Hotline, operated by the Delaware Coalition Against Domestic Violence, provides confidential support and resources to anyone affected by domestic violence at 1-800-701-0800. The legal process for Krista Rule continues. The courts of Delaware will determine the outcome of the case against her, applying the full weight of the evidence and the law to reach a verdict that reflects the truth of what occurred on June 25, 2023, on Case Ridge Road in Dover. Denise Wood is remembered. If this story moved you, if it reminded you of the importance of understanding and addressing all forms of domestic harm, please take a moment right now to like this video and subscribe to Cold Case Hour. Leave a comment sharing your thoughts, and share this video with someone who needs to hear these stories. These cases are told because they matter, because the people at their center matter, and your support helps this channel continue that work. Subscribe now, and let's continue. Case 6, Kula Pelima. October 16, 2017. New Castle County Superior Court, Delaware. Investigators who work homicide cases will tell you that the nature of the work requires a particular form of emotional discipline. They learn, over time, to process what they encounter in a professional register that allows them to function, to gather evidence, to conduct interviews, to build cases, to pursue justice, without being overwhelmed by the human weight of what they are looking at. That discipline is necessary. It is professional, and it is, in most cases, achievable. Most cases. The case of Kula Pelima is, by the accounts of those who worked it, one of the cases that tested that discipline most severely. Not because of the complexity of the investigation. The facts, once established, were clear. Not because of uncertainty about what had occurred. The evidence was unambiguous. But because of what the evidence showed, a decision made by an adult woman in a moment of despair, panic, and complete moral collapse. A decision that resulted in the loss of 2 children. 2. Solomon Appel, 4 months old. Alex Appel, 5 years old. 2 children who had no part in the circumstances that led to that October evening. 2 children who were simply present, and whose presence became, in the distorted logic of a crisis mind, a problem to be solved. This is their story, and it is the story of how a Wilmington, Delaware courtroom became the place where the full gravity of what happened to them was met with the full weight of the law. In October of 2017, Kula Pelima was 30 years old and living in Wilmington, Delaware. She was, by most accounts, a woman managing multiple pressures, the responsibilities of caring for 2 young children, the logistical and emotional weight of an adult life, and a set of circumstances that were about to dramatically escalate. The father of the children, Victor Appel, was taken into custody by federal immigration authorities on October 6, 2017. His arrest by immigration enforcement officials was, for Pelima, a triggering event of the most destabilizing kind. The prospect of deportation proceedings, family separation, and an uncertain future appears to have driven Pelima into a state of fear and psychological crisis that, rather than leading her toward help, support, or any of the available community resources that might have assisted her, drove her toward a decision of incomprehensible finality. On October 16, 2017, 10 days after Victor Appel's arrest, Kula Pelima carried both children, Solomon, the 4-month-old infant, and Alex, the 5-year-old, into a bathroom in their Wilmington apartment. What occurred in that bathroom is documented in court records. Both children lost their lives in the water of that bathtub. Pelima subsequently called emergency services. When first responders arrived, both children were found in a condition from which no medical intervention could save them. The investigation that began that night moved quickly. Pelima was taken into custody within hours of the incident. When investigators interviewed Pelima, she admitted to what had occurred. She confirmed that she had been the person responsible for both children's passing. She described her state of mind in the days and hours before the incident, the fear, the desperation, the sense of a future collapsing around her. Her account was that of a person in profound psychological crisis. But psychological crisis, as painful and as real as it may be, does not and cannot constitute a legal justification for causing the passing of 2 children who had no choice but to trust the adult responsible for their safety. The charges brought against Kula Pelima were commensurate with the gravity of what had occurred. 2 counts of first-degree murder, reflecting the individual lives of each child lost. The prosecution proceeded through New Castle County Superior Court, where the case was tried and adjudicated with the full gravity that 2 counts of murder against young children demands. The trial that followed allowed the court, the jury, and the public record to fully examine what had happened in that Wilmington apartment on October 16, 2017. The evidence was presented, the circumstances were examined, and the jury, having considered everything before them, rendered verdicts of guilty on both counts. Kula Pelima was convicted of 2 counts of murder in the first degree. She was sentenced to life in prison. Life in prison. The most severe sentence available under Delaware law, reflecting the judgment of the court and the jury that what occurred on October 16, 2017, was an act of the gravest magnitude, one for which the law provides no greater accountability than a lifetime of incarceration. The sentencing proceedings were, by all accounts, emotionally devastating for everyone present. The court heard statements that addressed the weight of losing Solomon and Alex, a 4-month-old who had barely had time to enter the world, a 5-year-old who was old enough to have been aware of his surroundings, old enough to have known something was wrong, old enough that the circumstances of his final moments are particularly difficult to fully consider. The case had a dimension that advocates and legal observers noted carefully. Pelima's stated motivation was rooted in fear of immigration enforcement. This aspect of the case generated significant discussion in legal, advocacy, and community circles, not as a means of excusing what occurred, but as an illustration of the ways in which institutional fear can drive individuals toward catastrophically irrational decisions when they feel they have no path forward. Immigration advocacy organizations, domestic violence support networks, and child welfare agencies across Delaware and the broader region pointed to this case as evidence of the urgent need for immigrant families and families in any form of institutional crisis to have accessible, trusted pathways to support. A person experiencing the kind of fear and desperation that Pelima described needs to be able to reach someone who can help them, someone who can redirect them toward options that do not lead to irreversible tragedy. None of this changes what happened to Solomon and Alex. None of it restores 4 months of life or 5 years of life to 2 children who deserved all the years that followed. The accountability rendered by the New Castle County Superior Court, life imprisonment, reflects the irreversible nature of what was taken. Solomon Appel was 4 months old. Alex Appel was 5 years old. They were children under the care of an adult who chose a path that no fear, no desperation, and no crisis could ever justify. They are remembered. If you or someone you know is experiencing a crisis related to immigration, family separation, or any situation that feels overwhelming and without options, please reach out for help. The Delaware Hispanic Commission provides resources and referrals for immigrant families at 3027394554. Support is available. Options exist. Help is reachable. If this story affected you, if Solomon and Alex's story reminded you of why child protection must be a community priority, please like this video, leave a comment below, and subscribe to Cold Case Hour. These stories are told because the people in them deserve to be remembered, and because awareness is the foundation of prevention. Subscribe now and stay with us. Case 7, Mary Vinson. January 1st, 2020 through October 31st, 2021. Kent County Superior Court, Delaware. There is a particular horror in the slow crime. The crime that does not occur in a single explosive moment, but accumulates over days, weeks, and months, building in severity, expanding in scope, and persisting in darkness precisely because no single incident is dramatic enough, visible enough, or public enough to trigger an alarm. These are the crimes that happen in isolated spaces, behind closed doors, enforced by the authority and physical dominance of adults over children who have neither the means nor the opportunity to seek help. These are the crimes that, when they are finally uncovered, reveal a depth of sustained cruelty that challenges the comprehension of everyone who encounters the evidence. The case of Mary Vinson is that kind of case. Over a period of approximately 20 months, from the beginning of 2020 through the autumn of 2021, a group of children living in a home in Houston, Kent County, Delaware experienced a level of prolonged harm that a Kent County Superior Court judge, upon reviewing the totality of the evidence and hearing the guilty plea of the defendant, described as the most extensive and persistent evil he had seen in his years on the bench. That is not a characterization offered lightly by a judicial officer. It is the language of a person who has spent a professional lifetime in the most difficult spaces of the criminal justice system and who found, in this case, a situation that exceeded even that experience. Mary Vinson was 46 years old at the time of the events described in this case. She was the stepmother of the children in the household, a role that carries with it the full legal and moral weight of parental responsibility, the same duty of care that biological parenthood demands, and the same criminal accountability when that duty is violated. The presence of her husband, Charles Vinson, in the home added a dimension of adult complicity to the situation that prosecutors addressed in separate proceedings against him. For the purposes of this case, the focus is on Mary Vinson, the individual who stood before Kent County Superior Court, entered a guilty plea to 30 felony counts, and received a sentence of 106 years in Delaware State Prison. 30 felony counts. 106 years. Those numbers require a moment of consideration before the details of the case are examined, because they speak to the scope and the severity of what was perpetrated against the children in that Houston, Delaware home over 20 months. The charges against Mary Vinson included kidnapping, the most serious charge in the indictment, reflecting the court's determination that the manner in which the children were confined, controlled, and prevented from accessing the outside world rose to the level of deprivation of liberty. They included multiple counts of child abuse, reflecting the range of documented harmful conduct toward multiple child victims over an extended period. They included strangulation, an offense that, under Delaware law, carries its own serious weight as an act of violent physical control. And they included reckless endangering, covering a range of conduct that placed the children's well-being in serious jeopardy. What the evidence established, through the investigative work of Delaware State Police, the Division of Family Services, and the Kent County Prosecution Team, was a household in which children were subjected to a systematic regime of deprivation and control. Food was withheld as a form of punishment and control. The children were required to endure physical exertion, standing for prolonged periods, being subjected to physically punishing activities as instruments of the adult's authority. Physical harm was administered. The children's access to the outside world, to school, to community, to any adult outside the household who might have witnessed their condition or heard their accounts, was deliberately restricted. 20 months. Through the beginning of 2020, which coincided, it should be noted, with the onset of the COVID-19 pandemic and the broader societal lockdown that further isolated families from community oversight, through the summer of 2020, the fall, the winter, into 2021. Through all the seasons of a school year, through circumstances in which the pandemic's disruption of normal institutional contact made the children's isolation even more complete and more difficult for outside institutions to detect. The intersection of this case with the COVID-19 period is a dimension that child welfare advocates noted with particular concern. The pandemic's closure of schools, its disruption of social services home visits, its reduction in community-based oversight of vulnerable children. These factors created a period of heightened risk for children in abusive situations that researchers documented extensively in the months and years that followed. Mary Vinson's case is, in Delaware's records, one of the clearest examples of how that risk materialized into documented harm. The children eventually came to the attention of authorities. The precise circumstances of how the situation was reported are part of the investigative record. What followed was a careful, thorough investigation that documented the conditions of the household, the physical condition of the children, and the evidence of what had been occurring over the preceding 20 months. When investigators and child welfare workers finally accessed the situation, what they documented was, in the words of the judicial officer who oversaw the sentencing, evidence of evil that had persisted beyond anything the court had previously encountered. Mary Vinson was taken into custody. The investigation was completed. Charges were filed. And on the date of her guilty plea, she stood before the Kent County Superior Court and entered admissions of guilt to 30 felony counts covering the full range of harm perpetrated against the children in her care. The sentencing hearing was an occasion for the court to apply the full weight of Delaware law to conduct that warranted nothing less. The judge, in delivering a sentence of 106 years, a sentence that, given Vinson's age at the time of sentencing, effectively constitutes a life sentence in practical terms, made clear that the systematic, sustained, deliberate nature of the offenses against multiple child victims over an extended period demanded the most serious response the court could provide. 106 years. The children at the center of this case, their identities protected, as they should be, throughout the legal proceedings and in this documentary, survived. They were removed from the household. They were connected with support services, counseling, and the kinds of sustained interventions that children who have experienced prolonged harm require in order to begin the long process of recovery. Recovery from what these children experienced is not measured in weeks or months. It is a process that extends across years, sometimes decades, and requires the consistent, compassionate, and professional support of therapists, educators, caseworkers, and, where possible, stable and nurturing family or foster care environments. Delaware's system of child welfare services was deeply engaged with the ongoing well-being of these children following the conclusion of the criminal proceedings. The case stands, in Delaware's recent history, as one of the most extreme documented examples of what the sustained, deliberate mistreatment of children under one's care can look like when it goes unchecked for an extended period. It is a case that demands not only accountability, which the court provided, emphatically, but also reflection on the systems of oversight and early intervention that exist to identify situations before they reach this severity. Mary Vinson is serving 106 years in Delaware State Prison. The children she harmed are alive. They are, in the fullest sense of the word, survivors. And survivors deserve every resource, every form of support, and every commitment from the communities and institutions around them to ensure that what they experienced is acknowledged, addressed, and never allowed to be forgotten as a lesson about what happens when children are invisible to the systems meant to protect them. If you are a mandatory reporter, a teacher, a neighbor, a community member who has concerns about the welfare of children in your community, please contact the Delaware Child Abuse Reporting Line at 1-800-292-9582. Reports can be made anonymously. Every call could matter. Please take a moment right now to like this video and subscribe to Cold Case Hour. Leave a comment below. Share this story with someone who should hear it. Your support helps this channel continue covering the cases that need to be seen and heard. Subscribe now. Let's continue. Case 8, Detoshia Spence. April 17, 2015. Sussex County Superior Court, Delaware. The town of Laurel, Delaware sits in the southwestern corner of Sussex County, a small, close-knit community of roughly 4,000 residents surrounded by the flat, agricultural landscape that defines much of Delaware's interior. It is a community that knows itself well, where people recognize faces, where news travels quickly, and where tragedy, when it arrives, settles over the entire community rather than just the households directly involved. In the spring of 2015, tragedy arrived in Laurel in a form that shook that community profoundly. The passing of a 3-year-old child, the investigation that followed, and the eventual accountability rendered by a Delaware court for one of the most serious offenses in the state's criminal code. Her name has not been released publicly throughout the court proceedings, consistent with standard practice in cases involving very young child victims, and this documentary will honor that protection fully. She was 3 years old. She was in the care of Detoshia Spence, a person entrusted with her well-being, responsible for her safety, and in a position of complete parental authority over her small life. On April 17, 2015, emergency services were called to a residence in Laurel. A 3-year-old child was found in a condition that required immediate medical attention. The child was transported from Sussex County for emergency treatment. The injuries documented by medical personnel were serious and, upon evaluation by physicians experienced in pediatric trauma, were inconsistent with any accidental cause. They were instead consistent with what investigators would subsequently confirm: physical harm, deliberately inflicted, over a period that extended beyond a single incident. The child did not survive her injuries. Delaware State Police, in coordination with the Delaware Division of Family Services and the Sussex County Attorney General's Office, opened a homicide investigation. The investigation proceeded methodically, examining the physical evidence, the medical findings, the timeline of the child's life in the weeks and months before April 17th, and the accounts of individuals who had contact with the household. What investigators documented was a pattern of conduct that went beyond a single incident of harm. The child had experienced repeated abuse over a period of time, a pattern reflected in the charges that prosecutors ultimately brought, which included not just the most serious charge arising from her passing, but additional counts addressing the documented history of harm prior to the fatal incident. Detoshia Spence was identified as the person responsible. She was taken into custody and charged with murder by abuse or neglect in the second degree, 2 counts of second-degree child abuse reflecting the documented pattern of prior harm and endangering the welfare of a child. The case moved through Sussex County Superior Court. The investigation was thorough. The evidence was substantial. And Detoshia Spence, faced with the weight of the evidentiary record assembled by investigators and prosecutors, entered a guilty plea to the charges against her. At sentencing, the Sussex County Superior Court heard from those whose lives had been altered by the loss of this 3-year-old child. The community impact of what had occurred, the grief, the questions, the desire for accountability that communities always feel when a child's life is taken by the person responsible for protecting it, was present in that courtroom in the way it always is in cases of this kind. The court sentenced Detoshia Spence to 15 years in Delaware State Prison, to be followed by 6 months of home confinement and 2 years of supervised probation upon release. The 15-year sentence reflected the court's judgment of the gravity of the offense, a judgment that placed the value of a 3-year-old child's life at the center of its deliberations. 15 years. For a 3-year-old who never had the chance to become 4. Sussex County, like Kent County and Newcastle County, has grappled in the years since this case with questions about how to strengthen the mechanisms of child protection in communities where resources are sometimes limited, where geographic isolation can reduce the frequency of institutional contact with vulnerable families, and where the cultures of small-town privacy can sometimes work against early identification of children in distress. The Delaware Child Abuse Prevention Initiative, along with Sussex County-specific resources operated through the Division of Family Services, has worked to establish stronger community-level touchpoints for child welfare, including family resource centers, visiting nurse programs for families with newborns, and expanded collaboration between pediatric health providers and child welfare investigators to ensure that injuries presenting in clinical settings receive the investigative scrutiny they warrant. Every such initiative carries, behind its policy language and its program frameworks, the memory of children like the 3-year-old who lost her life in Laurel, Delaware, on a spring day in 2015. Children whose stories became, against their will and in the wake of their loss, the arguments for doing better. Detoshia Spence is serving 15 years in Delaware State Prison. The child she harmed, 3 years old, known to her community, deserving of every year that followed, is remembered. If this case moved you, please take a moment to like this video, leave a comment below, and subscribe to Cold Case Hour. Every subscriber, every like, every comment is a vote for continued coverage of the cases that matter. Subscribe now, and let's continue. Case 9, Valorie Handy. January 28, 2015. Sussex County Superior Court, Delaware. There is a particular form of trust that parents extend when they hand their child to a caregiver. It is not simply logistical, a matter of scheduling and childcare arrangements. It is, at its core, one of the most profound acts of trust that a parent performs. The implicit agreement is total. I am placing the most precious thing in my life in your hands. I am trusting you with their safety, their comfort, their well-being, and their life. When that trust is violated, when the person to whom a child has been entrusted causes harm rather than providing safety, the consequences extend far beyond the immediate legal proceedings. They extend into the community of parents who trusted, the profession of childcare providers whose collective reputation bears the weight of every individual failure, and the systems of licensing and oversight that exist precisely to ensure that the people entrusted with children's care are equipped, responsible, and safe. The case of Valorie Handy, a licensed home daycare provider in Millsboro, Delaware, is a case about that trust, about its violation, about the loss that followed, and about the legal accountability that Delaware's courts provided in its aftermath. On January 28, 2015, a 10-month-old boy named Charles Laws III, known to his family and community by the nickname Trey, was in the care of Valorie Handy at her licensed home daycare in Millsboro, Sussex County, Delaware. Trey was an infant at the threshold of his development. At 10 months, he was in that remarkable stage of early babyhood where the world is beginning to resolve into recognizable shapes, where familiar faces bring comfort, where the sounds of a caring environment lay the earliest foundations of what security feels like. Trey did not come home that day. Emergency services were called to Handy's Millsboro residence. Trey was found unresponsive and transported to emergency medical services. Despite efforts to save him, he did not survive. He was 10 months old. The investigation that followed was conducted by Delaware State Police in coordination with the Sussex County Division of Family Services and the Office of Child Care Licensing, which oversees the regulation and inspection of licensed child care facilities in Delaware. The investigation examined Handy's home daycare operation, the circumstances of January 28th, and the conditions that had existed in the facility in the days and weeks prior to the incident. What the state medical examiner's analysis revealed was significant. Trey's passing was attributed to diphenhydramine intoxication. Diphenhydramine is the active ingredient in over-the-counter antihistamine medications, including commonly available products like Benadryl. It is a substance that, when administered to infants, can cause profound respiratory and neurological suppression, with potentially fatal consequences. Medical guidance is unequivocal. Diphenhydramine should not be given to infants. It is not a safe sedative. It is not an appropriate substance to use in any childcare context for any purpose. The presence of diphenhydramine in Trey's system as the cause of his passing raised immediate and serious questions about how it came to be in his body. It does not appear there spontaneously. It is administered, and the investigation focused on the circumstances of its administration in the context of Handy's care for Trey on that January day. Valorie Handy was charged with murder by abuse or neglect, the most serious charge available under Delaware law in this category, reflecting the prosecution's initial determination that the circumstances of Trey's passing warranted the fullest possible legal response. The case proceeded to trial in Sussex County Superior Court. The jury heard the evidence, the forensic findings, the medical testimony regarding the effects of diphenhydramine on an infant, the investigative findings related to the circumstances at the daycare, and the broader context of Handy's operation of her licensed facility. The prosecution argued for conviction on the most serious charge. The defense addressed the facts and circumstances as presented. After deliberation, the jury reached a verdict. Valorie Handy was convicted of criminally negligent homicide, a lesser charge than the original murder by abuse or neglect count, but one that nonetheless placed her squarely within the framework of criminal responsibility for Trey's passing. The jury's determination was that while Handy bore criminal responsibility for the circumstances that led to Trey's passing, the evidence supported the lesser charge rather than the most serious. The sentencing that followed in Sussex County Superior Court resulted in a sentence of 2.5 years in Delaware State Prison. For the family of Charles Trey, Laws 3, that sentence, like all sentences in cases involving the loss of a child, carried the bittersweet weight of accountability achieved alongside grief that no sentence can fully address. The broader implications of this case for Delaware's childcare regulatory system were significant. The Office of Child Care Licensing conducted a review of its inspection protocols in the aftermath of the Handy case. The question of how to ensure that licensed home daycare providers are maintaining appropriate standards of care, standards that include, at their most fundamental level, not administering inappropriate substances to children in their care, became a priority for state regulators. Licensed home daycare providers in Delaware are subject to a regulatory framework that includes background checks, facility inspections, staff training requirements, and compliance with health and safety standards. That framework exists because the state has a responsibility to ensure that the trust parents extend when enrolling their children in licensed care is backed by credible, rigorous oversight. The Handy case illustrated, in the starkest possible terms, the consequences when that framework fails to prevent harm. It also illustrated the importance of continued vigilance, of parents asking questions about the care their children receive, of licensing agencies conducting meaningful inspections, and of the medical community maintaining awareness of the signs that a child may have been exposed to inappropriate substances. Trey Laws, 10 months old, with a nickname that his family gave him with love, with a whole life ahead of him, deserved the full protection of every system and every person responsible for his safety. His case changed the conversations about licensed childcare oversight in Sussex County and contributed to statewide reviews of childcare regulatory practices. That contribution was not sought. It was imposed by tragedy. But it is real, and it carries Trey's name with it. Valorie Handy served her sentence. The regulatory systems that licensed her facility were examined and strengthened in the aftermath of her case. The legal accountability rendered by Sussex County Superior Court was proportional to the verdict reached by the jury. And Charles Trey Laws 3, 10 months old, loved, and gone too soon, is remembered. Parents who have concerns about the quality of care in a licensed childcare setting in Delaware may contact the Office of Child Care Licensing at 302-8925-807. Reports of concerns about child care provider conduct can be made and will be investigated. If this story affected you, if Trey's story strengthened your commitment to asking hard questions about child safety in every context, please like this video, leave a comment below, and subscribe to Cold Case Hour. Your support matters. These stories matter. Subscribe now, and let's go to our final case. Case 10, Casey Layton and Doyle Hundley Jr. May 23, 2015 through September 22, 2015. Sussex County Superior Court, Delaware. We reach the final case in this documentary. And in doing so, we arrive at a case that, in certain respects, encapsulates everything this documentary has been examining. The catastrophic consequences of parental failure, the devastating vulnerability of infants who are entirely dependent on the adults around them for protection, and the capacity of Delaware's criminal justice system to deliver accountability when the evidence leaves no room for evasion. Harbison, Delaware is an unincorporated community in Sussex County, a rural area south of Georgetown and north of Lewis, surrounded by the open land that defines much of Delaware's southern county. It is not a place that frequently appears in statewide news. It is a quiet community, the kind of place where a family living in a modest residence can go about their lives without much external scrutiny. In the spring of 2015, a family in Harbison included a very young infant. Layton Hundley was 3 months old. He was in the care of his mother, Casey Layton, and his father, Doyle Hundley Jr., adults who, by every legal and moral measure, bore complete and total responsibility for his safety, his health, and his survival. On May 23, 2015, emergency services received a call from the Harbison residence. Layton had been injured. First responders arrived and found an infant in critical condition. He was transported immediately to BB Healthcare in Lewis, the nearest hospital capable of addressing his condition. The severity of his injuries was such that BB Healthcare staff arranged for his immediate transfer to AI DuPont Children's Hospital in Wilmington, the state's premier pediatric hospital and one of the leading children's medical facilities in the region. At AI DuPont, physicians conducted a thorough evaluation of Aiden's condition. What they documented was devastating. Multiple broken bones and severe head injuries. The kind of injuries that pediatric trauma specialists recognize as entirely inconsistent with any accidental cause and entirely consistent with the deliberate application of physical force to a 3-month-old infant. An infant who weighed, at 3 months, a matter of pounds. An infant whose entire body fit in an adult's hands. The investigation by Delaware State Police began immediately. The nature of the injuries, the age of the child, and the forensic analysis all pointed toward a clear conclusion. Both Casey Layton and Doyle Hundley Jr. became the subjects of a criminal investigation. The evidence gathered by investigators, physical, forensic, and testimonial, documented what had occurred in that Harbison residence, sustained, repeated physical harm inflicted upon a 3-month-old infant over a period leading up to and including May 23, 2015. Layton Hundley remained on life support at AI DuPont Children's Hospital. His medical team worked to address the severity of his injuries. The weeks that followed were a period of clinical effort and familial anguish, the kind of sustained uncertainty that comes when a young life hangs in the balance of both medical intervention and the irreversible damage that had already been done. On September 22, 2015, 4 months after the initial emergency call on May 23, Layton Hundley passed away at AI DuPont Children's Hospital. He was 8 months old. He had spent half his life in a hospital, the result of injuries inflicted in his own home in the first weeks of his existence. The passing of Layton Hundley transformed the criminal investigation into a homicide investigation. The Delaware Attorney General's office, working with the Delaware State Police, prepared charges that reflected the full gravity of what the investigation had established. Casey Layton and Doyle Hundley Jr. were each charged with murder by abuse or neglect in the first degree, Delaware's most serious charge for cases involving the passing of a child as a result of abuse or neglect by a person in a position of custodial responsibility. Each was also charged with endangering the welfare of a child. The legal proceedings moved through Sussex County Superior Court. The evidence assembled by investigators was, by every account, substantial and compelling. Both defendants, in the face of that evidence, made the same legal decision. They entered guilty pleas to the charges against them. Casey Layton appeared before the court and admitted her role in what had happened to Layton. She received a sentence of 15 years in Delaware State Prison. Doyle Hundley Jr. appeared before the court and admitted his role in what had happened to his son. He received a sentence of 20 years in Delaware State Prison. 20 years for the father. 15 years for the mother. Both convicted of murder by abuse or neglect in the first degree. Both entering guilty pleas that acknowledged, before the full weight of the court and the community, that Aiden Hundley's passing was not an accident, not a tragedy without agency, but the direct result of their conduct toward a child who had no ability to protect himself. The sentencing disparity between Layton and Hundley reflected the respective assessments of culpability made by prosecutors and the court in the context of the investigation's findings, a determination that, while both adults bore criminal responsibility, the degree of that responsibility was not identical. The case resonated deeply in Sussex County and across Delaware's child welfare and law enforcement communities. Aiden's case, an infant, 8 months old at passing, whose entire life outside the womb was marked first by injury and then by the medical efforts to keep him alive, became a reference point in discussions about infant safety, about the specific vulnerabilities of very young children to physical harm, and about the systems of oversight that exist to identify and respond to situations of risk before they reach irreversible conclusions. Shaken baby syndrome and other forms of inflicted infant injury are among the most significant and most preventable causes of serious harm to children under 1 year of age in the United States. Research consistently identifies the first few months of a child's life as a period of heightened risk, coinciding with the intense stress of new parenthood, sleep deprivation, the overwhelming demands of an infant's constant care needs, and the absence of adequate support systems for parents who may be struggling. Delaware's Period of Purple Crying Program, a nationally recognized initiative designed to help parents and caregivers understand and manage the normal but intense crying phase of infancy, is one of the state's primary tools for preventing inflicted infant injury. The program acknowledges the real difficulty of caring for a persistently crying infant while providing clear, evidence-based guidance on safe coping strategies. It is offered through Delaware's hospital system and pediatric health providers to parents of newborns. Aiden Hundley deserved a family that, when the stress of new parenthood became overwhelming, reached for help rather than for harm. He deserved a system that was close enough to his family to identify the risk before May 23rd. He deserved the years that followed 8 months, the childhood, the adolescence, the entire life that was never allowed to unfold. Casey Layton is serving 15 years in Delaware State Prison. Doyle Hundley Jr. is serving 20 years. Aiden Hundley, 3 months old when he was injured, 8 months old when he passed, and deserving of every day he never received, is remembered. If you are a new parent, a caregiver, or someone supporting a family with a very young infant, and you are experiencing the kind of stress and frustration that caring for a crying baby can bring, please know that help is available. The National Parent Helpline is available at 1-855-42-72255. It is not a sign of failure to need support. It is a sign of honesty, and that honesty could save a child's life. If Aiden's story, if all 10 stories in this documentary, have left you with a deeper understanding of why child protection must be a community priority, please like this video right now and subscribe to Cold Case Hour. Leave a comment below. Share this video with someone who needs to hear these stories. Every subscriber, every like, every share is a contribution to this channel's mission of bringing these cases into the light, because the light is where accountability begins, and accountability is where justice lives. Thank you for watching. Thank you for caring. Subscribe to Cold Case Hour, hit the notification bell so you never miss a story, and we will see you in the next one.